Fortunately, we have a definition. None of the human rights document describe what human rights is. But one of our document describes it. That is a very bold step. Protection of Human Rights Act, Section 2(1)(d). It describes human rights means the rights relating to life, liberty, equality and dignity of the individual, guaranteed by the Constitution or embodied in the international covenants and enforceable by courts in India. So this is a description, and according to this description, human rights are those rights which are, number one, guaranteed by the Constitution, and as all fundamental rights and only the fundamental rights are guaranteed by the Constitution, therefore all fundamental rights automatically become a part of human rights. Second is, those rights means relating to life, liberty, equality and dignity, which are embodied in the international covenants and enforceable by courts in India. They are also human rights. So there are great possibilities that there are many rights which are not guaranteed by the Constitution, like the part of directive principles of the state policies. But if they are embodied in the international covenants and made enforceable by the courts in India, then they become human rights. So just because they are a part of international covenants like ICCPR, UDHR, refugee laws and others, they do not become a part of human rights for the purpose of India. Though they are human rights, there is no doubt, because they are part of international documents. But for our purpose, if we go through this Protection of Human Rights Act document, then not only they should be a part of international covenants, but they should also be made enforceable by courts in India. So, besides fundamental rights, other human rights are very limited so far as India is concerned. That's why, take example of refugee laws. India is not a party to Refugee Convention. India is also not a party to Rome Statute of International Criminal Court. But regarding refugees, we have often heard that human rights are violated, technically speaking, because we are not party to refugee conventions. PHRA section 2(1)(d), they are not part of human rights. Now, what are the human rights which are connected with fundamental rights? We can take example of freedom of expression, we can take example of personal liberty, we can take example of right to reputation. And various human rights documents have also recognized it, like UDHR Article 19 and 20, they recognize freedom of expression. International Covenant on Civil and Political Rights, Article 19. Incidentally, our fundamental right, the Constitution of India, Article 19 itself, they recognize freedom of speech and expression. Their regional conventions also, they also recognize human rights, like European Convention, like South African Convention, they recognize various human rights. But as no rights are absolute, similarly no human rights are also absolute. But this part is little talked about, that all human rights come with their limitations, their restrictions. So even UDHR Article 29, ICCPR International Covenant on Civil and Political Rights Article 12, they all come with various restrictions, various limitations. For example, you can read Article 12 of Clause 3, which is in the bold letter, that all these rights are subject to national security, public order, public health, morals, freedom of others, consistent with the other rights recognized in the present covenant. So all human rights are having various restrictions. So human rights do not come with restrictions. When we talk about human rights, there are restrictions which go with human rights. Now, so these are the part of human rights that I wanted to discuss in the beginning. that what is the meaning of human right, what is the extent, and what are the limitations. Second important variable is sedition, or law of sedition. Now, in order to understand this law of sedition, let us understand, which is very clear, that freedom of speech and expression does contain discussion, disagreement, dissent, disapproval, and criticism. And disagreement, dissent, and disapproval, they are part of democracy, and no democracy can survive if there is no dissent, no disagreement, no disapproval. So I can criticize an individual and you can criticize an individual, but then there is a boundary. If you cross the boundary, law comes in. And what is the boundary? Boundary is clearly prescribed under Article 19 of the Constitution. 19 Clause 2. There are 8 restrictions, 8 limitations, like sovereignty and integrity of India, like relations with foreign states, like state security, like public order, like incitement of offense, like morality and decency, like contempt of court, like incitement of offense. There are 8 restrictions. So I can talk about anyone, but I cannot defame the person. If I defame the person, section 499 of IPC comes in. Can I criticize a community? Yes, I can criticize a community. It is freedom of speech and expression. I can criticize Hindu community for their traditional role in sati and their role currently in dowry traditions and their role in not giving equal rights to property even after it has been made a law. So I can criticize Hindu community. Can I criticize Muslim community? Of course I can. That they are still very much adamant to their traditional laws which were made 1400 years, and they say that no, touch me not, you cannot reform it. What is this all nonsense and democracy? We are not a theocratic country. We have something like fundamental rights. We talk about gender justice. If the laws are being reformed, you should be ready for that. I can criticize them, community. But then there is a boundary, and boundary is under Article 19.2, as I told, which is made enabled, which has been enabled, which has been made enforceable by various provisions of IPC. Take example of 153A, 153B, 295A. We cannot criticize religion in such a fashion that the criticism is unreasonable. So there are various provisions under IPC for that. Can I criticize an institution? Certainly I can criticize an institution. Can I criticize the parliament? Of course. Subject to rules, like civil servants are bound by certain rules, but teachers are not bound by. I don't know about your rules, but there is a code of conduct. Probably you cannot criticize the parliament except through your judgment. And I am not aware whether subordinate means district judges, officials are allowed or not, or is it only the monopoly of high courts and supreme courts to criticize the parliament and executives. But teachers can criticize the parliament and can say that if we go through the antecedents of the parliamentarians, it seems that good number of them have criminal antecedents, and it seems that parliament has become a den of criminals. Can I criticize the Supreme Court as an institution? Yes, I can criticize. I have a fundamental right to criticize. Can I criticize the sub judice case? Of course I can criticize. Every day in the channel things are going on. There should not be any confusion that sub judice cases can be criticized. Sub judice cases can be discussed. There are Supreme Court judgments on that. So I can criticize the institution like parliament. I can criticize the institution like Supreme Court. Can I criticize the, of course, when I criticize the institution, if I cross the boundary, contempt of court comes in. If I criticize the parliament unreasonably, without any restriction, then there are privileged motion that is there. Can I criticize the state? Yes, I can criticize the state. It is a democracy. Democracy is meant to criticize. One of the meaning of democracy is that you can question the government, you can question the state, you can question the policy of the government, you can question the state. That the state has failed to secure the employment of people, that the state in certain cases failed to deal with COVID. Can I criticize? Yes, I can criticize. But again, if I cross the boundary, there are certain provisions that come in picture, and one of them is law of sedition, section 124A. I will go to the definition clause. What is law of sedition? But we have published a work, ILI has published a book on sedition law, and we have given our own definition. And what is our definition? Our definition is that sedition is a calculated expression. It is not just an expression. It is a calculated expression. It is expression of extreme form. It is against state, not generally against government, but against state. And then the statement or the expression must contain tendency of violence or disorder. These are our description. Now, because the topic is law of sedition, is law of sedition limited to section 124A? It's a misnomer. Law of sedition is not limited to 124A. Means if you want to criminalize the expression against the state, it is not limited. See the laws which are there. IPC 124 is just maybe a pillar, central pillar. But then CRPC provisions section 195, 108 and 196. 108 uses the term 124A. There are special criminal laws also. Seditious Meetings Act 1911, Dramatic Performance Act 1876. Then a number of acts I have mentioned. Even in Citizenship Act, there are provisions for disaffection. There is a Criminal Law Amendment Act 1961 which is existing. Unlawful Activities Prevention Act UAPA, there is a provision for disaffection. A number of laws are there which deals with one form of disaffection or other form of disaffection. 2 or 3 of them have been repealed in 2017, but most of them still exist. So law of sedition is not just one law, 2 law, it is a group of a number of laws. And they are existing. Let me come to the definition clause. Please read this definition and then please give me the liberty to raise these 2 questions which are mentioned in bold. And I would seek the answer from the learned gathering. What do you feel about it? So please read this provision carefully and do answer me. I will begin with the last question. What is the punishment range, minimum to maximum? And anyone who has done, just raise his hand, so then his or her hand, so that
3 years.
बताइए
3 years.
3 years is the minimum.
10 to 3 years.
Up to 3 years. So maximum punishment is, you mean to
Or fine. Or fine.
So I am not clear. I want to know what is the minimum punishment, what is the maximum punishment.
Minimum fine.
Minimum is fine. Only fine. Okay. So a person commits sedition and you can acquit him without going to jail, you can just give him fine. Is it okay? Is it the right position in the law? ध्यान से देख लीजिए फिर से.
Fine is in addition to 3 years.
Pardon?
Fine is in addition to 3 years.
3 years means in addition to 3 years means 3 years तो देना ही पड़ेगा उनको.
Yes.
Sure about that? फिर से देखिए उसे आप. फिर से देखिए, कोई बात नहीं है. डाइवर्सिटी तो व्यूज की डाइवर्सिटी तो होनी चाहिए.
3 years.
यही पर्पस है ट्रेनिंग प्रोग्राम का.
Fine only.
Only fine.
Life for 3 years or
Minimum
only
fine
fine.
and maximum 3 years.
So
Maximum 3 years.
for the clarification of this class, maximum punishment, I think there is no dispute. Life imprisonment.
Yes.
Is there any dispute on that?
No.
Minimum punishment seems there is some confusion, but some people feel, most of them feel it is fine only, but some feel no, it is 3 years also. What is the exact status?
Fine.
Fine only.
Only fine.
Fine. So sedition is an offence which can be dealt with when a conviction takes place. Only fine can be given. How do you decide the gravity of a crime?
Impact.
Huh?
Impact on the society.
Impact to the society is what?
Participation of the offender.
Is the gravity of how do you decide the gravity of an offence?
Whether he actually participated.
No, the IPC provisions are there. If you want to know which offence you think is a serious offence, how do you decide it? Punishment. Punishment, we say that murder is the most of the grave because it has capital punishment. Then 364A also contains capital punishment. 310 also capital punishment. We say they are most grave because of capital punishment. Punishment is one way besides what you are telling, that is correct. That punishment is one way to understand what is the punishment that shows that okay how grave the punishment is, how grave the offence is.
The
So
impact that has happened after that incident in the society at large.
I think this is very subjective. I'm talking about objective criteria, that how do you decide. So if fine is a punishment and that mere fine can be a punishment, generally we say that offence does not seem to be serious. We generally say, I'm not telling that it is always correct, but generally we say traffic offences, fine हो जाता है. हाँ? Mere fine is punishment. So first myth to me is that sedition has been projected as a very, very serious type of crime because there is a life imprisonment, ignoring the fact that fine is also a punishment. Which people do not know either because they are ignorant or they are smart enough. I don't know what is the reason. I'm talking about media. Why fine is mere punishment? The English were very harsh to us. They could have made only maybe life imprisonment, 3 years, fine हटा ही देते. Why? Because it is a speech crime. If violence is committed, there are provisions under IPC. Huh? If there is no violence, चुपके चुपके कर दिया तो conspiracy का provisions है. Abatement कर दिया कहीं पर तो abatement की provisions है. Offences तो है. 124A, you know, 1860 IPC आई थी, 1870 में सेडिशन को लाया गया अमेंडमेंट करके 1870 में. 1870 में 2-3 अमेंडमेंट हुए, सेक्शन 34 भी अमेंड हुआ था जो बहुत ही फेमस है, हम सब जानते हैं, कॉमन इंटेंशन. 1870 में 124A was incorporated, though the proposal came in 1837 through in the Macaulay draft itself. 1870 में ये आया, but fine was why? Because they were also aware that this is an area where there are people who speak something which is not liked by us. So there are two types of people, two category of people. There are some who are professional type of thing. They have intention to uproot us, that is the English. But then there are others who are just followers. There are others who are maybe youngsters. There are others who are just energetic. दुनिया बदल देंगे टाइप का, हाँ, वो बोल देंगे तो उनके लिए इतना प्रोविजन होना चाहिए कि फाइन भी हम कर सकते हैं. I will come to another slide, but then another question, that first question, whether it is strict liability crime.
No.
जल्दी बताइए क्योंकि मैं घड़ी देख रहा हूँ 4 बजने जा रहा है.
Hey, no.
It is not a strict liability crime. Okay. और कोई?
Sir, would you clarify the question?
Whether it is a strict liability crime means whether mens rea is an essential part of this crime or not.
No, not it.
Whether when the if you are trying this case, so considering you are a competent court, I find some ADJRs also there. They are competent for this. Will you ask the prosecution to establish mens rea also or not? No. Anyone? Who says yes? Mens rea will be required. It is not a strict liability offence. It is a general liability offence like murder. Intention भी चाहिए या knowledge भी चाहिए.
The main intention for this offence is defection to the government.
हाँ.
The main intention for this offence is disaffection to the government.
That is okay, but point is that will you seek the prosecution to establish that it was intentional or not?
Yes, spoken words are enough.
Or spoken words are enough? Suppose someone says that अरे भाई ये तो मुझे तो ऐसा पता ही नहीं था मैंने गलती से बोल दिया यार. तो will you consider this statement or आप बोलेंगे कि नहीं 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 ये सब नहीं चलेगा. आप देखिए इसमें intention word तो है ही नहीं. mens rea word कहाँ है इसमें?
Because this involves even life imprisonment. There the gravity will increase. So there probably mens rea is required to be proved.
I don't think that is the correct approach.
Many of the
Because offense has to be decided objectively, based on the element, not based on the punishment. Even if fine is there, the criteria would be objective in all cases. If the offense is one, I will just cut short. The provision does not use any mens rea words, either knowledge or intention. The highest degree of mens rea is the intention, then knowledge, or then reason to believe. But intention is an essential part of this. It is not a strict liability crime. And this is the second myth, which becomes the reasons of misuse of strict liability crime, law of sedition, which many times the police officers and sometimes the judicial officers also commit. They consider it is a strict liability offense. अब बोल दिया तो बोल दिया. वो जैसे होता है ना कि तीर निकल गया आपकी कमान से, तो बस अब तो आप रिस्पॉन्सिबल हो गए उसके लिए. कोई मर्सी नहीं. ठीक है, आप कंटेक्ट नहीं जानते थे, गलती से बोल दिया, जोश में आके बोल दिया, हम कुछ नहीं सुनेंगे. अब हो गया सो हो गया. Be very clear, this is a mens rea positive crime. This is not mens rea neutral or mens rea negative crime. What is my authority? My authority is the various judgments which were delivered right from 1891 Bangowasi case to till date. They have clearly mentioned that intention is an essential element and prosecution shall be required to establish intention. इंटेंशनली बोला है, जानबूझ के बोला है, गलती से नहीं बोला, सारा कुछ जानते समझते बोला है. Prosecution will always be required. ठीक है? Now because these words are not there, maybe pre-COVID, this is post-COVID, this is the first judicial officer training program, we have done it previously. So pre-COVID we used to do police officers also. I have asked the police officers because they are the first protectors of human rights. Judiciary comes the next. Second protector of human rights is judiciary, first protector is police. So they said that नहीं इसमें क्या देखेंगे, हमें क्या देखना है इसमें? इसमें तो कोई word है ही नहीं, and they are correct. We cannot expect the police officers, 90% of them are not LLB. LLB is no qualification of police officers. ट्रेनिंग होती है, उनकी जरूर होती है. सो तो देख लेते हैं, इवन इफ विद द बेस्ट ऑफ द इंटेंशन. अभी बताया मैडम ने कि हाँ पुलिस से त्रस्त है सभी. मैं थोड़ा उसको डाइल्यूट करना चाहूंगा कि ठीक है बात तो सही है, उनकी अपनी कंपल्सन है. विद बेस्ट ऑफ द इंटेंशंस देयर आर पुलिस ऑफिसर्स. वो बोले कि भाई कैसे करें, वी हैव टू इन्फोर्स लॉ, और इंटेंशन तो है ही नहीं इसमें. मर्डर का केस आएगा तो हम तो जरूर देखेंगे 304A में जा रहा है कि नहीं जा रहा है, क्योंकि भाई होमिसाइड तो 3-4 प्रकार की हो जाती है। हम देखेंगे 302 में जा रहा है कि 4 में जा रहा है कि 304A में जा रहा है, लेकिन यहां तो कुछ देखना नहीं है। दिस इज अनदर रीजन फॉर मिसयूज, बिकॉज द इंटेंशन वर्ड इज नॉट देयर। सो वी हैव रिकमेंडेड दैट द पार्लियामेंट और द स्टेट लेजिस्लेचर, बिकॉज स्टेट भी इसको अमेंड कर सकते हैं, ये तो कॉन्करेंट लिस्ट का विषय है। कांग्रेस ने कहा भी था कि हम तो आते ही इसको हटा देंगे, पर अभी तक अपने किसी स्टेट में कोई अमेंडमेंट लाया नहीं हुआ अभी तक। और लिबर्टी के सबसे बड़े वाहक जो है कम्युनिस्ट पार्टी, वो भी अपने स्टेट में कभी नहीं लाए अमेंडमेंट, कभी नहीं लाए। दिस नो शोज द हिपोक्रेसी। हिपोक्रेसी, यू कैन अमेंड सीआरपीसी एंटी सेपेटरी बेल तो यूपी में था ही नहीं, 498 है, कहीं जगह कंपाउंडेबल है, तो आप कर देते हैं इसको, क्यों नहीं चेंज कर दिया आपने? So I think we have suggested that this should be amended and intention word should be incorporated. This is also one reason why one judicial officer has also committed a blunder in UP. Arun Jaitley has written, Arun Jaitley when he was a minister, he wrote a piece on Facebook पे लिखा उन्होंने। एनजेएससी का जजमेंट आया था, नेशनल जुडिशियल अपॉइंटमेंट कमीशन, आपको पता है जब सुप्रीम कोर्ट हैज डिक्लेयर्ड एनजेएससी एज अनकॉन्स्टिट्यूशनल, 99 कॉन्स्टिट्यूशनल अमेंडमेंट इज अनकॉन्स्टिट्यूशनल 4:1 में। उसके बाद रात में बैठ करके जैसे बहुत सारे पार्लियामेंटेरियंस थे, सभी दुखी थे, वैसे वह भी दुखी थे, तो उन्होंने वे पोस्ट लिखी, पोस्ट में लिखा, थोड़े कड़े शब्दों में लिखा, इट इज टिरेनी ऑफ जजेस। इस तरह के 3-4 वर्ड्स का इस्तेमाल किया। यूपी के एक जुडिशियल ऑफिसर को अरुण जेटली की बात बहुत खराब लगी। अरे कैसा कह दिया, हमारे सुप्रीम कोर्ट को कह दिया ये बात। सुओ मोटो कॉग्निजेंस ले लिया उन्होंने 124A का मामले पे। किसके अगेंस्ट में? अरुण जेटली के अगेंस्ट में। अरुण जेटली के अगेंस्ट में नहीं ले सकते, ऐसा नहीं है, ले सकते हैं, क्यों नहीं ले सकते? पावर है सीआरपीसी में, हम तो लॉ को एनफोर्स कर रहे हैं। 124A का मामला अरुण जेटली के अगेंस्ट में उनका शुरू हो गया, इसलिए कि फेसबुक पे उन्होंने लिखा। क्यों? क्योंकि सीआरपीसी के प्रोविजन को मुझे ऐसा लगता है उन्होंने ऐसे ही पढ़ लिया, इस बात को सोचे बिना कि उनका उद्देश्य क्या है। Is he expressing his disappointment against the judgment? Is he criticizing? No, nothing doing. वही वर्ड, कहाँ वर्ड है? स्पोकन और लिखा है गवर्नमेंट, आपने कैसे कर दिया? Anyway, so that case was ultimately quashed by the High Court. There are 3 explanations to it. Disaffection includes disloyalty and all feelings of enmity. So disloyalty. So we need to be loyal. इसे बताने की जरूरत नहीं है. Every citizen has to be loyal to his country. But disloyalty to whom? Why should I be loyal to the government?
Loyal to the state.
I should be loyal to the state. I should be loyal to the country. I should be loyal. I have to be loyal to the constitution, even if I like or don't like it.
Sovereignty to the constitution.
But why should I be loyal to a government? Be it a government of Congress party in Chhattisgarh, be it a government of BJP in UP. I may be dead against a government. It is my fundamental right to remain dead against. But disloyalty not to the government, but certainly to the country. If you say something against country, Bharat tere tukde honge, it shows your disloyalty to the country. If you say Azad Kashmir chahiye, it shows you are not loyal to our country and its integrity. There may be problem, there may be dissatisfaction. There are ways to resolve it. So disloyalty not to the government, but disloyalty to the country is non-tolerable. There is no compromise, zero compromise if there is disloyalty to the country. Then explanation 2 and 3 says, which also dispels the third myth that अगर आप criticize करेंगे तो बंद कर दिया जाएगा. अभी one of the Supreme Court judge has said it. मैं तो अगर बोल दूंगा कि क्या है मोदी जी ने ऐसा, मुझे जेल में बंद कर देंगे. How foolish this statement is.
State टीयर.
प्राइम मिनिस्टर की क्रिटिसिज्म आप देखना चाहते हैं? आप जाके ट्विटर अकाउंट खोल के देखिए क्या क्या कहा जाता है प्राइम मिनिस्टर को हर रोज. 50 लाख पोस्ट ऐसी होगी जिसमें प्राइम मिनिस्टर, अमित शाह, सुप्रीम कोर्ट को, मैं उन वर्ड्स का इस्तेमाल नहीं कर सकता जो जुडिशरी के बारे में कही जा रही है. आप देखिए क्रिटिसाइज किया जाता है. व्हाई डू यू से क्रिटिसाइज नहीं कर सकते? आपको जेल में इनको बंद कर दिया जाता है केवल क्रिटिसाइज करने से. किसने कहा? देयर आर केसेस, नो डाउट, बट दैट डज नॉट मीन दैट एवरीवन इज डूइंग लाइक दैट. Explanation 2 and 3 clearly says, explanation 2 and 3 clearly says that comments expressing disapproval, word छूट गया इसमें, disapprobation of measures of the government, disapprobation and criticism, disapproval of the measures of the government with a view to obtain their alteration by lawful means. आप criticize करिए, क्रिटिसाइज करने का राइट दिया हुआ है आईपीसी में, एक्सप्लेनेशन 2 और 3 में दिया हुआ है. दिस इज द थर्ड मिथ कि भाई अब 124A को क्यों जाना चाहिए? क्योंकि गवर्नमेंट के अगेंस्ट जब क्रिटिसाइज करेंगे तो लॉ ऐसा नहीं है. सेक्शन इज ओके, इट इज द एक्शन दैट इज प्रॉब्लमेटिक. सेक्शन इज वेल, कोई प्रॉब्लम नहीं है सेक्शन में. आई हैव डेल्ट विद दिस, मैंने डिस्कस कर लिया है क्या एलिमेंट्स है. आप कोई बात बोलते हैं और वो बोलने के साथ when you speak that thing, if you write something, then your intention is to bring hatred, contempt or disaffection. आपका इंटेंशन ऐसा है which is required to be proved. बट आपका इंटेंशन का मतलब सब्जेक्टिव इंटेंशन नहीं है. आपके इंटेंशन का मतलब ऑब्जेक्टिव इंटेंशन है. रिजनेबल मैन क्या समझता है आपके इंटेंशन को लेकर? इट इज नॉट subjective intention, it is objective intention. And if you do like that, dissatisfaction, you do contempt or hatred against the government. Now this word is redundant, it's not just against the government. Least used, this should be least used. तो मैंने पहले भी कहा है against state, not just the government. ये अंग्रेजों के समय में था. आप सरकार के अगेंस्ट में कोई बात नहीं कर सकते थे. ठीक है, आपने सुना होगा दुष्यंत कुमार ने कहा है, मत कहो आकाश में कोहरा घना है, यह किसी की व्यक्तिगत आलोचना है. और डेमोक्रेसी में हम आ गए तो सब तो सरकार की आलोचना कर ही सकते हैं. कभी कभी हम रिजनेबल आलोचना भी कर सकते हैं. एवरी डे विपक्ष और पक्ष आपस में क्या करते हैं? आप भी पढ़ते हैं, बोलते हैं कितनी अनरिजनेबल बात कह दी इसने. अनरिजनेबल आलोचना भी करते हैं. तो सरकार की आलोचना जो है वो गवर्नमेंट established by law in India should also be amended. उसको स्टेट कर दे तो शायद ठीक हो जाएगा. एक्सप्लेनेशन हम लोगों ने चर्चा कर लिया है. जल्दी में बस केस लॉ जो है थोड़े से देख लेते हैं हम लोग. पहला इंपॉर्टेंट केस था बंगोवासी का 1891 का. आपको पता 1870 में आया था. 1891 में बंगोवासी केस था. इसमें सेडिशन सेक्शन 124A को इंटरप्रेट किया गया. Then Tilak was tried, Lokman Bal Tilak was tried in 1897, 1908 and 1916. Annie Besant was tried in 1916. Dr. Hedgewar, the head of RSS, was tried in 1921, 1930. Very less known facts. Mahatma Gandhi was tried in 1922. Dr. Hedgewar and Mahatma Gandhi both accepted that yes, we have said we have committed sedition against the British government. Tilak has justified his statement. He has not accepted, but he said कि नहीं हम तो आपका यही कर रहे हैं, हम तो आपका समर्थन कर रहे हैं. Then Pandit Jawaharlal Nehru was also tried in 1930 and 1934. Then there are 5 cases which are significant, which will be probably the concluding part. Before Kedarnath Singh, I will definitely discuss Bharti Press case, Shailbala Devi case, which is very significant. Bharti Press case is a constitution bench judgment, less known judgment, but it's a constitution bench judgment. Bharti Press, which is probably not mentioned. It's a Bihar case. it has developed a test, and known of the test is in toto test. In toto test means if a book is under question, if a statement is under question, if a pamphlet, if a leaflet is under question, if a speech is under question, you cannot pick up just one paragraph and declare it seditious, declare it against law. You have to read the complete paragraph and then find what seems the intention of the person. Then you strictly read all the paragraph. Don't read again in favor of the accused. You read it strictly, no problem. But read the whole paragraph. So just because if you translate this today, if there are tweets, you cannot just take up one line of the tweet. You cannot take up one line of the paragraph, which the judicial magistrate of UP has done. He has taken just one line or two lines from that paragraph, ignoring that there is a Supreme Court judgment to which he is bound. That in toto test should have been there. So let us not commit this mistake. Maybe उसने 50 लाइन में से एक लाइन ऐसी कह दी हो जो बहुत ही हमको खराब लगे हो, लेकिन बाकी लाइन अगर ठीक है, then it is a criminal matter. Administrative तरीके से उसको डील किया जाएगा. But ये criminal matter, there is no need to prosecute the person. Why? Even if you think that criminal law should take note of, don't go for 124A, go for 108 of CRPC. अच्छे कंडक्ट के लिए जमानत की प्रतिभूति लेने का प्रावधान है उसमें, but that is not being used. 107, 108, this provision is there, that is not being used. 108 specifically mentions 124A, which is not used. Why do you register an FIR? Why do you register a complaint? Why don't you ask for 124? Why 108 cannot be used under CRPC? So Bharti press case. Now this is applicable in all cases, even in contempt cases also. In toto test is applicable in all cases. Then second is the controlling precedent of 124A, that is Kedarnath Singh, State of Bihar, 1962 Constitutional Bench judgment. This says that 124A will be unconstitutional if we do not read tendency of violence or disorder in the section 124A. आपने देखा होगा जब ये प्रोविजन मैंने आपके सामने रखा था, इस प्रोविजन में कहीं भी ये वर्ड नहीं है. टेंडेंसी ऑफ वायलेंस और डिसऑर्डर इस प्रोविजन में कहीं भी नहीं है. But then through Supreme Court amendments, Supreme Court decision, interpretation, it has become a part of law of the land. This is probably the fourth reason, because it is not amended and the provision is as it is. Probably the police officers, sometimes maybe judicial officers who may not be aware of what is the judgment of Kedarnath Singh, they also commit this blunder and FIRs are registered and sometimes arrest takes place because they are not looking for tendency of violence or disorder. But take note, Kedarnath Singh does not say that actual violence or actual disorder is required. Mere tendency of violence or mere tendency of disorder is sufficient. Actual violence or actual disorder is not required, because if actual violence or actual disorder is there, 124 will not be required. There are a number of provisions for that in IPC. Third is Balwant Singh case. This Balwant Singh case is the fifth myth. In Balwant Singh case, what happened? On the day our late Prime Minister was assassinated, Indira Gandhi was assassinated in 1984, then two Sikh people with clerical staff, government staff, came out from the office and started passing slogans like Khalistan जिंदाबाद, राज करेगा खालसा, हिंदुओं को पंजाब छोड़ के जाना पड़ेगा, अब बारी आ गई है खालसा राज बनाने की, वगैरह वगैरह स्टेटमेंट उसने दिया. And they were arrested and section 124A was imposed on them. Besides other laws, the matter came to the Supreme Court. The Supreme Court held that mere passing of a couple of slogans for a few times by a person who is not very influential does not amount to sedition. So what is the ratio of the case? The ratio of the case is that if someone passes slogans which is anti-India slogan, but the slogans are just one or two types which was made in Balwant Singh, and the slogans were made by someone who is not influential like the clerical staff, and the slogans had no impact. People did not bother for him. क्या बोल दिया छोड़ो यार, बोल दिया क्या फर्क पड़ता है. That does not amount to sedition. This is the ratio of Balwant Singh. How the Balwant Singh ratio is being misinterpreted? Balwant Singh ratio is being misinterpreted that Balwant Singh has legitimized all anti-India slogans. So even if in JNU in 9th of January 2016, the slogan has been made, भारत के टुकड़े होंगे इंशाअल्लाह इंशाअल्लाह, बंदूक के दम पर लेंगे आजादी. वगैरह वगैरह, they are also legitimized. That again is a misreading of Balwant Singh judgment. Balwant Singh judgment does not say that a calculated expression is also legitimized. It says if an expression is made suddenly, is sudden outburst because Indira Gandhi was assassinated, sudden outburst by someone who is not influential like clerical staff, it will not amount to sedition. But on the other hand, if the slogans are very serious slogans, they have been planned, they have been made not one or two times but a number of times, there was impact of that slogan, that whole country was very agitated, very disappointed, then those slogans will not be protected by Balwant Singh judgment, they will amount to sedition. Arun Jaitley case I have already discussed with you. Common cause case 2016 is not very significant. It only says that Kedarnath Singh verdict has to be followed by all police officers, all magistrates. Vinod Duai's recent case of 2021, where again the Supreme Court has dealt with this Kedarnath Singh and other cases, and held that Kedarnath Singh still holds the field, Vinod Dua, and the law should not be misused just because Vinod Dua has made some allegation about Prime Minister. Allegations may be inappropriate, but they are not illegal. Finally, 2022 VG Wombarke case, where the Supreme Court has stayed the execution of Section 124A. So this is the development. Now, how this law now looks like actually? This is actually the law in force. The law of 124A, which is in the statute book, is not the law. Correct law is this one. That intentionally and then with causes tendency of violence and disorder. I think if this is understood, probably 90% of the misuse cases can be taken. Finally, what is the suggestion? How can it be reformed? That of course there can be amendment that can be brought in. Offence can be made bailable, if not in all cases, but in certain cases. Section 124A was bailable indeed. Currently it is non-bailable. Prior to 1973 it was bailable. During Indira Gandhi regime it was made bailable, non-bailable. So similarly, Section 108 of CRPC, that is still there, that is not being used. That can be used. If this is used, then probably the abuse cases can be taken. So with that, I just thank everyone for the attention, and the questions are welcome. I understand that time is past, and probably if any one of you ask the question, others might treat them as a very serious, with a very open eyes. But still the questions are welcome. If you have any questions, I will love to answer those questions. Thank you very much.